Because when Congress enacted the Mining Act of 1872, it gave miners the opportunity to go on federal land and seek gold. But it didn't guarantee them that. It didn't guarantee they'd find anything. It didn't guarantee that they would find enough to make a profit. It encouraged them to do it, but it didn't.
Counsel, as I understand it, your argument is that the federal law does not, the California law that's coming out of California's concern with the environment. Do you want to elaborate on that, or is that the beginning and the end of your argument?
Well, I think Mr. Rinehart has conceded that California can adopt what he calls reasonable environmental regulation.
And does he concede, I'll hear from him, but that this is reasonable environmental?
No, of course, he characterizes it in a way that's unreasonable, but I think quite reasonable what the legislature did here.
So is what you have to argue against the idea that because banning the sucking method removes any economically feasible or commercially feasible method of mining, that it's preempted? Is that what you have to defend?
No, we didn't ban suction dredge mining.
I'm sorry, I can't hear you.
I'm sorry. We did not ban suction dredge mining. We placed a moratorium on it for a period of time while an environmental review was proceeding.
So what's the difference between banning it and establishing a moratorium, other than that there's a moratorium could come to an end, but as long as the moratorium is in place, it's banned. Isn't that right?
Right. A moratorium can be characterized as a temporary ban, certainly.
So I'm not sure that assertion is compelling as an answer to Justice Werdegar's question, to say, well, we didn't really ban it, we just established a moratorium. I don't think that gets you there.
Well, it may be that I didn't understand Justice.
May I ask you the question without, I remember reading it, but I want to hear from you. I know the legislature had and gave great consideration before it imposed the ban/moratorium. So and I know that the state acted in a way to regulate protection and public use. What did it find, the state find, were the dangers of suction mining? Why do they need to conduct an environmental study of such a thing?
The reason that this environmental review was done was because suction dredge mining is, what it is putting a vacuum in the bottom of a river and sucking the gravel and the rocks and the dirt out. And what that does is it affects the habitat of fish. And specifically what caused this environmental review to happen was that there were threats to endangered salmon in Northern California. And the concern was that was affecting, that suction dredge mining was affecting those endangered fish. So there are those concerns. There are also concerns because suction dredge miners target areas that were mined previously. And California has a history of using mercury to mine. And so there is mercury in the sediment in the rivers that we have where these fish live, but that also flow to San Francisco Bay, that when suction dredge miners do their work, they pull all of that mercury out, and it ends up in sediment in the water column and flows down to where people live.
Which is your argument that this is quintessentially a police power exercised by the state to protect the environment, and that the Mining Act from 1872, enacted after the gold rush, as you said, the Wild Wild West, to encourage mining and settle property expectations, never meant to displace the state's inherent sovereign authority to regulate the environment of its land and waterways for public use.
Yeah, I agree. And there's further evidence after the Mining Act of 1872. California banned the mining method of hydraulic mining, and Congress took notice of that. It knew that it affected all those businesses, and it, instead of affecting that ability to ban hydraulic mining, it set up what was called a debris commission to further regulate hydraulic mining. And so that's further evidence that Congress didn't intend to upset this police power.
You've mentioned the text several times, going back to the prison discussion, and I certainly accept and believe that the text can tell us a great deal about what the legislature is trying to accomplish. But help me zero in on the text that you think is most helpful to your position.
It's the phrase, under regulations prescribed by law.
Got it. So your argument is that piece of the statute is underscoring that what the legislature is trying to accomplish here is to protect a sphere of police power for the state.
Yes, because the word law is normally meant to include federal, state, and local laws. And that's also emphasized by the last phrase, which says, so far as the same are applicable and not inconsistent with the laws of the United States. So laws in comparison to laws of the United States, the difference underscores that that's meant to protect state law.
Do you see Section 21A of Title 30 as being relevant in terms of considering what the operative purposes of the federal statutory scheme are? Should it play a role in our consideration of this issue or not?
Certainly. I mean, the United States filed an amicus brief in this case, and they made the point that this provision, as well as other federal laws, recognize that the environment is part of the balancing, and that mining isn't to be encouraged at all costs, that there are environmental needs, that's the phrase that it uses, that need to be taken into account as well under the Mining Acts. I've lost track of time, but I think my time is
Your
up.
time's expired. You'll have 8 minutes for rebuttal.
Thank you.